Today we're going to talk about disorderly intoxication. Disorderly intoxication is not just being drunk in public. Even though police sometimes mistakenly believe that being drunk in public is disorderly intoxication, it's not sufficient to support the charge. For a disorderly intoxication conviction, the state must prove that the person was intoxicated and endangered the safety of another person or property, or that the person was intoxicated and caused a public disturbance. The key to a disorderly intoxication defense is determining whether or not the person was intoxicated. There's a very specific definition of intoxication in the state of Florida. Intoxication is defined by statute and in the jury instructions as intoxication means more than merely being under the influence of an alcoholic beverage. Intoxication means that the offender must have been so affected from the drinking of an alcoholic beverage as to have lost or been deprived of the normal control of either his or her body or his or her mental faculties, or both. Intoxication is synonymous with drunk. However, being drunk does not mean that you have been lost the normal control of your body and or mental faculties. There's a distinction between intoxication and impairment in Florida. DUI is driving while impaired, not while intoxicated. That's because it's much harder to prove intoxication than impairment. You must have been so affected from the drinking that you've been deprived of the normal control of their body. Pretty hard to prove. Disorderly intoxication is a second-degree misdemeanor, punishable by up to 60 days in jail or a $500 fine. Whenever we analyze a disorderly intoxication case, we analyze whether the person meets the definition of intoxication, and simultaneously, we evaluate whether or not the behavior that's being criminalized was actually protected by the First Amendment. You cannot be prosecuted for protected speech and actions. Again, police often mistakenly believe that they can, but there can be a constitutional argument in regards to the behavior that was allegedly led to the arrest for the disorderly intoxication. If you're facing a disorderly intoxication charge in Palm Beach County and you need legal assistance, please reach out to Leroy Law. We'll give you a comprehensive defense tailored to the facts of your case, and we'll help you get through this charge. We can be reached at 561-290-2730.